Sir, I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe.
The hearing begins as Judge Green calls the case of State of Michigan versus Frank Michael. Prosecutor Mohammed states his appearance for the people, while Frank introduces himself as the beneficiary of an estate and claims he is appearing special, not general. Judge Green explains that the purpose of the day is the preliminary examination, outlining 3 charges: felon in possession of a firearm, carrying a concealed weapon, and felony firearm. The prosecutor confirms readiness to proceed, but Frank says he first needs a better understanding of jurisdiction. Judge Green reminds him that the court has already ruled on this issue, yet allows him to briefly make a record before moving forward.
This is 210736FY. This is State of Michigan versus Frank Michaud. May I have your appearances, please?
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Would you state your name for the record, sir?
My name is Frank Michaud. I am the beneficiary of the Frank Anthony Michaud estate that you are administrating over, and I appoint you as the trustee for the record. Let the record show. I am here as making a special appearance, not general. I am here on the threat, duress, and coercion.
Thank you, Mr. Michaud. Today is the day and time scheduled for the preliminary examination. In this matter, there is count 1, weapons, firearms, possession by felon. Count 2, carrying concealed weapon. Count 3, felony firearm. Are the people prepared to proceed?
We are, Your Honor. We do have a couple of preliminary matters.
Before we do that, Mr. Michaud, are you prepared to proceed?
No, ma'am. I'm actually here to get a better understanding of things first before any proceedings.
What is it that you need to get a better understanding of, sir?
For one, is the jurisdiction that the court is operating upon.
Judge, I'm going to object. The court has made a decision on this motion previously. Both you and Judge Oakley had ruled on this, so I'm going to object.
Mr. Mohammed, hold on one second. Mr. Mohammed, what we will do is let Mr. Michaud make his record.
Yes, ma'am. Okay. Constitution, the 6th Amendment grants me the right to know the nature and the cause of the action. I know the jurisdiction that you're operating upon for the record.
The next thing, sir. The next thing. You said you had some preliminary matters, which suggests more than one thing.
Frank attempts to question the court's jurisdiction again, claiming he needs clarity before any proceeding begins. Judge Green responds that this matter has already been addressed multiple times by her and by Judge Oakley. She explains the case involved criminal allegations arising from an incident at Detroit Metro Airport in February 2021. The judge outlines that Frank was ineligible to possess a firearm due to a prior controlled substance conviction, and the charges stem directly from this. Despite this explanation, Frank restates his question, insisting the jurisdiction is unclear, prompting the judge to remind him that repeating a question will not change the answer.
What's next?
Is this going to be criminal, civil or criminal? And I also want to, with the basis of that answer, I would like to address some other things as well.
What other things, sir?
It's pertaining to off your answer. So,
Mr. Michaud, I think we had this conversation last week. Correct me if I'm wrong. This is a criminal case. It is alleged that on February 23rd, 2021, at the Detroit Metro Airport, which is located in the city of Romulus, you committed the following: that you did possess and or transport and or purchase a firearm when ineligible to do so because you've been convicted of violation of Controlled Substance Act 333.74012 4012A4, a specified felony, and the requirements for regaining eligibility had not been met. Contrary to MCL 750.224F, count 2, carrying concealed weapon, that you did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, to wit, a Range Rover. Contrary to MCL 750.224. Count 3, felony firearm, that you did carry or have in your possession a firearm, to wit, a pistol, at the time you committed or attempted to commit a felony, to wit, felon in possession of a firearm. Contrary to MCL 750.227B, there is also an habitual offender third offense notice on the file where it's alleged that You were convicted of the offense of violation of Controlled Substance Act on October 24, 2013, and convicted of the offense of attempt carrying of a concealed weapon on April 30th, 2002. That being the case, the court having responded to the charges indicated to you that this is a criminal matter. The court's question back to you, sir, is are you prepared to proceed with the exam in this matter?
No. You still haven't stated the jurisdiction.
Judge Green reads each count into the record with full statutory references. She describes the felon in possession charge under MCL 750.224F, explaining the legal basis for why Frank was barred from firearm possession. She then outlines the carrying concealed weapon charge, specifying the firearm and the legal statute involved. Finally, she explains the felon of firearm charge, clarifying that possession of a firearm during the commission of a felony enhances the offense. She also notes the habitual offender enhancement based on Frank's prior convictions. After fully explaining the nature of the charges, she again asks whether he is prepared for the examination.
Because Oakley stated that the jurisdiction of the court was Michigan statutes, and that's not what you're saying today.
Chief Judge Brian Oakley, you had a conversation with him about a month ago. We're having a conversation, we're having a hearing today. And sir, we're doing one of three things today. We are proceeding with the exam, you're waiving the exam, or we're adjourning this matter. Your response to my question right now is one of those three things. What are we doing this afternoon?
And you also stated that you addressed me having questions, and I had another question pertaining off your answer, and I wanted to read that.
Mr. Michaud, no, we're not doing this afternoon. Exam, waiver.
Well, at this moment, okay, since I'm under threat, arrest, and coercion, I would like to appoint Ms.
Instead of answering, Frank insists the judge still has not stated the court's jurisdiction in a way he accepts. Judge Green responds that this is the 34th District Court and that she has told him this repeatedly. She then outlines the three options for the afternoon: proceed with the examination, waive it, or request an adjournment. Frank continues arguing based on statements he claims Judge Oakley made, but Judge Green emphasizes that today's hearing requires a clear answer. She reminds him that she must move the case forward and will not delay the proceeding indefinitely.
Left, this court will proceed. Is that what you're indicating?
Well, you say I'm not under threat, right? And if I continue to ask a question, I will be held in contempt, which is a threat, right?
I never said contempt, sir.
Well,
What we are is scheduled for a hearing, and what this court does is hearings. And I entertained some of your questions, but it is now 2:15. And the court's, I know, sir, but I'm presuming that there will be some testimony.
Okay, but you're asking me, am I ready to proceed? And while you're asking me, you also telling me that we're about to proceed. So you're not actually giving me the right to answer the question. You also making it seem like you're threatening me. So
Mr. Michaud, I'm interrupting you to tell you that I'm not threatening you.
Okay,
but I've answered all that needs to be answered from this court to proceed with either the exam, a waiver.
Okay, all right. But you haven't answered the questions that I have asked. I said I had another question, and you're still not allowing me to ask the question. So do I have the right to ask?
What's your question, Mr. Michaud?
I just want to ask you, far as, hold on one second. I want to read this for you.
No, sir. You had a question. What is your question?
Can you help me understand this? Okay, according to 27 CFR 7211, it say all crimes are commercial and must have nature and cause and be prosecuted in the name of the people of the states as a real party in interest, not the people of the state, the corporation, the fiction. This is 20 FCFR, right? So I'll need you to elaborate on this code for me, please, and thank you.
Mr. Michaud, this court will decline to elaborate or respond to that because this afternoon we are here to determine if the prosecution is able to show that a crime has been committed and that probable cause exists to believe that you are in commission of that crime. That is what we're doing this afternoon.
I understand, but This says that possession of a deadly weapon is a commercial crime. So I need to have a better understanding if this is a commercial crime. You said this is a crime and there is no inter party where I hurt anyone. You haven't gave me the right to face my accuser. And it tells me, under this code, 27 CFR 72.11, all crimes are commercial. A deadly weapon is considered a commercial crime. So I understand that commercial is civil, but you're telling me this is criminal. So how is it criminal? And it says if there must be an injured party for a corpus delicti, for the record, an injured party, and you haven't presented an injured party for the record. So, I mean, can you elaborate on what jurisdiction you're operating under?
Frank continues questioning the process, saying he has further questions tied to the judge's answers. Judge Green explains that the purpose of this hearing is not unlimited questioning, but a scheduled preliminary examination. She reminds him that the court has already allowed more than enough opportunity for explanation. Frank insists that being prevented from asking more questions places him under threat or duress. The judge clarifies that no threat is being made and that the court is simply following procedure. She again directs him to choose whether to proceed, waive, or request adjournment.
You're asking a compound question, so I'm going to try to answer it. Last week and just now, you indicated a right to face your accusers. And you indicated that the court will be presenting something. The court is not presenting anything. The court will take testimony this afternoon and review evidence, documents, videos, whatever it is that either Mr. Mohammed or Mr. Sullivan on your behalf presents to this court. You want the right to face your accusers. I don't know who Mr. Mohammed is calling to give testimony this afternoon. I don't know who, if anyone, Mr. Sullivan is calling to give testimony this afternoon. That being the case, sir, are you prepared to proceed with the exam?
Okay, so the Chief Oakley said that he stated for the record that my accuser was the state of Michigan. And here in this code, it says the prosecutor in the name of the people of the states, not as the people of the state of Michigan. So what he said is contradiction to this code, and it's 27 Code of Federal Regulations 27/7211. All crimes are commercial. So I don't understand.
You were in front of Judge Oakley for a probable cause conference, which is basically a scheduling. Are we having an exam? Is there a plea or is there a waiver? For some reason, that didn't happen with Judge Oakley. You then had a PCC with Judge Green. Then you were with me for PCC last week. I asked you questions, you wouldn't respond, but I tried to answer your questions. And the people twice demanded an exam. And when you would not answer my questions, I scheduled the exam. Mr. Michaud, your only response right now is yes or no. Are you prepared to proceed with the exam this afternoon?
Well, under threat and threat and duress and coercion, I appoint Sullivan as my.
Frank argues that if he continues asking questions, he will be punished, claiming this makes him under threat. Judge Green firmly corrects him, stating she has never threatened contempt and is only trying to move into the actual examination. Frank insists he has more questions based on the judge's answers and asks if he is allowed to ask them. The judge, in an effort to resolve the issue, permits him to ask one final question. Frank then attempts to read from a document instead of asking a direct question, prompting the judge to insist he state his question clearly and concisely.
Mr. Michaud's record and Mr. Mohammed proffered to the court People versus Perkins. And Mr. Sullivan, the court has had the opportunity to review the opinion, and it does indicate that the defendant bears the burden of producing evidence to establish that his or her right to possess a firearm has been restored. That being the case, the court is accepting the certified record that was tendered by Mr. Mohammed. The court also has had the opportunity to hear the testimony of Officer Stempian. And for purposes of this preliminary examination, we'll find that the people have met their burden. And we'll bind Mr. Michaud over as charged. Mr. Michaud, your next appearance date will be on March the 13th, 2024 at 9 a.m. That will be at the Frank Murphy Hall of Justice.
Frank finally presents his question, citing 27 CFR 72.11 and claiming that all crimes are commercial and must be prosecuted differently. He argues that because there is no injured party, the case cannot be criminal. Judge Green declines to elaborate on the cited regulation and states that the purpose of the hearing is simply to determine probable cause. Frank insists that possession of a weapon is a commercial crime based on his reading of the regulation. He repeats that he has no accuser and no injured party, and therefore cannot understand how the matter can be considered criminal. Judge Green explains that Frank's question is compound and addresses one point at a time. She reminds him that the court does not present evidence. The attorneys do. His right to face accusers will occur through witness testimony, which will be given by whoever the prosecution or defense chooses to call. She reiterates that the scheduled purpose today is to hear testimony and review evidence. The judge emphasizes that his misunderstanding of the CFR does not change the nature of the charges. She again asks if he is prepared to begin the examination, pointing out that the state has twice demanded. Frank insists that Judge Oakley said the accuser was the state of Michigan and claims this contradicts the CFR passage he is quoting. Judge Green replies by clarifying Oakley's appearance was only a scheduling conference, not an evidentiary discussion. She reviews the sequence of earlier hearings, noting that Frank repeatedly avoided answering direct questions. After multiple delays and explanations, she tells him his only acceptable response now is whether he will proceed with the examination. Frank ultimately states he will proceed under threat and duress and designates his attorney, Mr. Sullivan, to act on his behalf. The court resumes after hours of testimony from officers and the introduction of certified criminal history records. Judge Green explains that the burden is on Frank to prove his firearm rights were restored and states that no such evidence was provided. She reviews the officer's testimony and finds that the prosecution met the probable cause standard on all counts. The judge formally binds Frank over to circuit court for trial and sets the next appearance date. She orders that the previously set bond and conditions remain in effect, concluding the preliminary examination.